So I was going to say there's not much happening right now, but there kind of is. So obviously I'm going to talk about the rights bill. With some caveats, I did a webinar on this, and I've already made mistakes in this bill. So it's complicated. It's 226 pages. I'm sure I'll say things today that you may or may not agree with. Don't go and make rash business decisions just because I've said something here. It's a complex beast, and I wouldn't honestly admit to say, I wouldn't honestly say I've got my head around all of it yet. And I suspect whatever I might think the law is about it, the Court of Appeal will probably have a totally different view at some point in 2 years' time. So just be aware of that possibility. So obvious stuff. Oh, I took out the first slide. Obviously, the thing to bear in mind is that the Renters' Rights Bill is the Renters' Reform Bill to some extent brought back, but you should be aware that there are real differences in the detail. So the overall conception is the same, and the wording in lots of bits is the same, but it's deceptive because it's not the same in all the details, and some of those really matter. So it's important to bear in mind that, that there are changes here, and just because you did something for the Reform Bill or knew something about the Reform Bill, that doesn't mean you know something about the Rights Bill. The two things are different, but often similar. Obvious headline stuff: no ASTs, no fixed terms, no Section 21, so all tenancies are assured periodic tenancies, which in effect means they are tenancies for life with specific grounds linked to specific events. Now that obviously creates an issue for landlords because Section 21 was quite open-ended and covered a whole slew of stuff. There are specific grounds linked to specific events. If you don't link to an event, you've got a problem and you're going to find it quite difficult to get possession, by which I mean you won't get it. Trying to grant something else is a prosecutable offence, or you can have a civil penalty for simply trying to persuade a tenant to have a Section 21, giving them a Section 21, giving them a fixed term. All of those things are unlawful. Now, one of the things that is bound to be problematic here is I'm talking to you guys, and let's be generous and say you maybe cover 1 million tenancies across the sector, but there are 5 million. So one of the problems that will be problematic across PRS is I'm going to get phone calls from hundreds and hundreds of landlords at some point after this is all in effect going, oh, I've just been served a civil penalty because I gave my tenant a 1-year fixed term. What's the problem? And it's like, well, unfortunately, and I should point, I still get calls from people who don't know that tenancy deposit protection exists. So lest you think, but it's so obvious, the level of awareness across the whole PRS is down here somewhere. And of course, part of the logic of things like the PRS database is to fix that. But if you don't know the database exists, then it's quite difficult to sign up for it. And so you won't get information. And Wales has had exactly this problem. Wales thought, oh, renting homes, how easy will that be? Because all landlords are now, of course, signed up to Rent Smart Wales. But they're not. And even more, even the ones who don't actually read the emails that Rent Smart Wales sends them. They just bin them. So lots of landlords just had no idea about renting homes, despite a fairly steady drumbeat of information. And obviously, budgets, this is not going to be on the ads around the 6 o'clock news. So the way of intersecting with the relevant population is quite low. I'm assuming people watch 6 o'clock news. It's probably just me, actually. So, lots of people will inevitably ask me at some point, is there not any lobbying effort that can be made to government to bring in fixed terms or something like that, as was done with the Reform Bill? Just so we're clear, no, there is not. Matthew Pennycook ain't interested, and in any event, they've kiboshed it because the long title of the bill explicitly says it's to abolish fixed-term tenancies, and therefore, even if you were to find the most friendly Conservative MP and persuade them to bring an amendment forward, the Speaker of the House would simply refuse to hear it because he's not permitted to, so the House rules will knock it out. So there is just no way that fixed terms are coming back in any form that I'm already had people saying, but what about for students? What about this? What about that? No. Not happening. Right, restrictions. This is where it starts to get quite interesting. So any restriction in any form of superior lease that says that you have to have an AST or a fixed term tenancy for less than the fixed term, or that you have to hand the property back with vacant possession, are all ineffective and become ineffective on grant. So that obviously means that you can't turn around and say, well, I have to grant you a fixed term because there's a superior lease that says that you can't do that. And that, of course, also means that all rent-to-rent arrangements that currently exist and will continue to exist across commencement are at risk because landlords who think they're going to get their property back with vacant possession from a rent-to-renter absolutely are not. The only exemption to this is that social landlords have a ground for possession where they are part of a rent-to-rent arrangement, where they have to hand the property back with VP. So social landlords may be the only remaining players in the rent-to-rent game after this, because they're the only people who'll be able to offer a genuine rent-to-rent deal where you get VP back.
It only puts them in the same position as a managed, doesn't it? Because neither can manage nor get their property back for any other reason.
Yeah.
If you amend your guaranteed rent, so obviously with a minority hat on, I'm all right, we can deal with it. Thank you.
But yeah, but obviously landlords on rent-to-rent arrangements now should be thinking about, are they happy with getting it back with whoever happens to be in there? Or alternatively, should they be terminating that rent-to-rent arrangement and moving to an alternative type of structure? Because the problem with rent-to-rent arrangements, as you know, is that there are good ones and there are less good ones. And the good ones, you tend to know who's in the property, it's pretty well set up. The less good ones, it could literally be anybody. I mean, there's also a side problem here, of course, is that it's going to become a lot more difficult to deal with unauthorized rent-to-rent as well, and you'll have to do so in a more complex way. Rent. My view on this, and my view hasn't changed on this, but I'm not so sure what MHCLG's view is, that you can't charge rent in advance. So you can only charge rent monthly or for 28 days. There's a slight difference against the reform, but you can actually charge shorter rent periods down to like a week if you really want to, but I'm kind of assuming you probably don't want to, actually. But nothing longer than a month is allowed, and any longer period will automatically set to a month. Now, this also has a side effect on commencement because longer rent periods in tenancies that carry over will reset automatically to 1 month at the point of commencement. So there's nothing unlawful about having a tenancy. I'm going to come back to this on students because this is a major problem for student tenancies that are being signed right now for next summer. Yeah, and might have a rent in advance clause. You can have a rent in advance clause up to the date of commencement, but as soon as it commences, that rent in advance clause is ineffective. It's not an offence to have one, but you can't use it. Okay, so the tenant chooses to pay you the extra money, then fair enough, but you can't make them. Okay, so effectively, rent in advance just can't be done. There's no legitimate mechanism to do it. They haven't changed the Tenant Fees Act. They should have done, really. And pointed that they should have actually put a clause into the allowable rent to say rent payments of more than a month are an unlawful fee, but they haven't actually done that. Well, they haven't done it yet. I just realised that MHCLG is listening to this discussion, so they might be busy writing that down now. Tenant notice, 2 months or such shorter time as you might choose to agree in writing, because obviously you'll be putting that clause into your agreement. Please give me less than 2 months' notice. One of the things I think is really interesting about this is that existing notice requirements in the Protection from Eviction Act are also subject to the common law. So the Protection from Eviction Act merely says that notice must be at least 4 weeks, but the courts have reinterpreted that and said on monthly tenancy it has to be a month expiring at the end of a tenancy period. I don't know if the courts will choose to reinterpret the government's 2 months as 2 months but expiring at the end of a rental period. I sort of feel like that one will be hitting the Court of Appeal pretty quickly. But obviously, one of the side effects of this is I assume most landlords are going to push the 2 month thing real hard, because why? Unless they've got someone else ready to go at a better deal. You cannot specify means of notice provided it's in writing. So if they want to email a notice to you, that's fine. But this is continually misinterpreted. You can specify the place or the person to whom notice must be given. So you can say you have to give my agent notice. And I noticed that after the reform bill, some tenants groups saying, oh, that means that people can't say you've got to give notice to my agent. Totally can. You just can't say how they have to give the notice as long as it's in writing. And there is a caveat here. Most of you operate other media accounts like Facebook or Twitter or WhatsApp. They're all in writing. So there's a real risk that those are all acceptable notice mechanisms as well. So get off that social media. Don't use it. I mean, obviously do, but bear in mind. And then the other point to bear in mind, of course, is one notice for one joint tenant binds all tenants. And this is very commonly used by social landlords, a normal common tactic of social landlords with assured periodic tenancies, especially in cases of domestic violence. is to get one tenant to serve them with a notice to quit and then use it to clear everyone out. In PRS tenancies, what tends to happen if one tenant gives notice is they try and do some kind of weird deal with the others. But you need to bear in mind, if we're doing a deal with the others, that's a new tenancy. And you'll have to take that onto account. And I suspect one of the outcomes here for a lot of tenancies, particularly at the lower end of the market, will be to try and persuade what tenant they want to go and give notice and use that to push everyone else out the door. Right, notices. So all notices will be Section 8 notices. And point to note here, Section 8 notices aren't changed by regulations anymore. They're whatever happens to be on the Secretary of State's website on the day you serve the notice. And he can change at any time. I presume he probably will tell you, but I wouldn't bet on it, and he doesn't have to. So previously it was easier. You got regulations, you usually had a warning, there was usually a draft, you usually get about a couple of days' notice at least. But you should bear in mind that if you've got an IT system with a Section 8 notice baked into it, which of course you will do because it's automatically filled in, there is a significant risk, if you're not keeping on top of it every single day, that the notice will change, you won't keep up with it, and that might impact the validity of your notice. I should also point out that it is an offence to serve an incorrect Section 8 notice if you do so negligently or recklessly or deliberately, or if you put the wrong grounds on it deliberately. So there are real issues here, and it's a rent repayment order too, just to add to the chuckles. So there are, and when I say it's an offence, not just for the landlord either, for you, if you're an agent. Yeah? Then notice periods are pretty much up across the board. Most of the no-fault type grounds, including I want to sell, is 4 months notice, so significantly longer. Rent arrears are up to 4 weeks, 2 weeks for most discretionary grounds. Interestingly, ground 12 remains at 2 weeks. And I suspect a lot more ground 12, which is breach of some other part of the tenancy agreement, that's going to be a popular place to go for evictions. And then ASB, still no notice, so ground 14. Although technically the court can't give a possession order to expire sooner than 14 days from the date of the notice. I'm looking at Paul as this because he's probably thinking the same thing, like, as if you'd be in court inside 14 days, come on. But in theory. So much so, and also if you add notices together, different grounds, then the longest ground rules, save for with ASB. But that doesn't mean you can just chuck ASB on every ground because it's an offence to recklessly or negligently or deliberately use a ground that you do not reasonably believe to be accurate. So be cautious about that. Right, rent arrears. So notice periods are doubled from 2 weeks to 4 weeks. Grounds 10, 11 are the same, but ground 8 is 3 months notice or 13 weeks notice if you're taking rent weekly. And the ground for repeated rent arrears in the Reform Bill ground 8A is gone, which I have to say I don't really care about because it was a bit of a rubbish ground anyway. But the combination of changes effectively means you're talking about effectively 4 months of rent arrears before you even start talking to the court. And I know the government keeps saying it's better, but I admit this is a High Court matter, but I put this on my LinkedIn this morning because I was so angry. I have a case where we issued an application for strikeout in June. We got a hearing date given us today, 3 months later. That hearing is March next year. And that's a High Court master. That's not even the county court. This is like the ones that are meant to be quick and sorted. So I put this on my LinkedIn and just complete annoyance. But I don't think that's a sustainable position. I just can't honestly see how the government can realistically expect people to accept 4 months arrears plus 6 to 8 minimum. So effectively a year of rent arrears. I don't think that's a sustainable position. Now, one thing that I think is quite interesting about this, actually, I'll come back to because this has already been mentioned by the government. The government has intimated that they think the amount of possession claims will drop. Now, the reason that they think this is going to happen is as follows. I don't agree with this, obviously. My assumption is to some extent they will double because all the existing Section 21 notices will just drop into the new system. The government thinks not. And the reason is that they think a percentage of Section 21 notices were just sort of trying it on stuff, like I wanted more rent and things like that. So they'll go. They also then have said that many tenants when faced with an obvious notice, will of course not choose to fight it and will choose to leave. But I have a more cynical view of this, and I suspect more tenants will actually fight because with a Section 21, you weren't really saying what the problem was. You weren't impugning their honour, as it were. You weren't putting them in a position where they had to tell the local authority why they were being evicted. Now, under Section 8, you'll be saying exactly why you're evicting them on a witness statement in court. And the reality is that not every tenant agrees that they're in rent arrears, or if they think they are for justifiable reasons, or whatever. Right, ground one I want to talk about. So ground 1A is the new ground possession where a landlord wants to sell. There is a 12-month minimum occupation period, which is up from 6. Now that's actually 12 months from the start of the tenancy to the expiry of the notice, so you can serve the notice at 8 months for 12. Okay? And there's a 4-month notice period, which is increased from 2 months. So obviously you have to have a pretty clear idea that you want to sell it quite far in advance of actually wanting to sell. This is not a situation where you suddenly get your mortgage renewal through and think, ooh, I better sell, otherwise I'm going to have a problem. I'm selling it in a while. It doesn't apply to assured tenancies created by succession from Rent Act tenancies, but that's not terribly interesting for most of you. There's also a restriction period. And that restriction period starts from the date you serve your Section 8 notice and lasts for the full 12 months from the date of expiry. So it's 12 plus 4. It's 16 months, the restriction period. If you seek to relet or market the property inside 16 months, that is a civil penalty of up to £7,000 for a first offence, rising to £40,000 if you leave it out there, not just for the landlord, but for the agent doing the marketing. So agents are effectively going to have to turn to all new instructions and say, did you evict the previous tenant for telling them that you were going to sell? And if the answer is yes, then sorry, we're not taking this one. Okay, I mean, someone else will, for sure, but you probably shouldn't. Yeah? So you're going to need to ask. And also, there's a rent repayment order attached to this as well. So under the Reform Bill, there wasn't a hell of a lot of enforcement. And people kept saying, oh, yeah, I'll just serve a notice, and I'll get my property. I should also say this is also a criminal offence. I mean, I've highlighted civil penalties because I think they're more common, but you can also be prosecuted for this stuff. So lots of people say, oh, I'll just tell the tenant I'm going to sell, but then just stick it back on the market. But the reality is they've ramped up the penalties. And one thing that's going to be an unpopular statement. In some ways, the Rights Bill is a much better bill than the Reform Bill from a purely legal sense. There are lots of things that are better thought through. Obviously, there are lots of things you don't like about it. I get that. But there are also a number of things in which legally it hangs together much better in terms of a structure. And obviously, having proper enforcement in respect of people breaking the law is legally better, albeit I accept less popular to some elements of the sector. But those people are planning to break the law, so my sympathy for them is limited. Okay? But you'll need to think very carefully about this. Rent increases. This has changed a lot, and in my opinion, is the most important thing. I'm totally overrunning. Am I all right to carry on?
You're fine.
Okay. This is the most important part of the whole thing. Far more important than all the Section 21 stuff. You can only increase the rent by way of a formal Section 13 notice. Anything else is of no effect and actually an offence. You can agree a rent increase, but only after having served a Section 13 notice for a lower sum than on the notice, or after a tribunal determination for a lower sum than the tribunal determined. Now that's changed from the Reform Bill, because the only agreement that was allowed under the Reform Bill was after tribunal determination for a lower sum. If you were a smart agent or landlord, your aim should be to serve a Section 13 notice and agree the increase for a lower sum than the Section 13, because tenants, there's 2 months' notice. Tenants can appeal to the FTT, and these appeals are free. There's no charge whatsoever for FTT appeals on rent increases. And if the tribunal has to determine it, the rent increase that they determine can't be more than your notice. It can be less, but it can't be more, which is a change from the previous bill, and comes into effect on the next rent period after the tribunal determination. It is not backdated to the notice, which it was under the previous legislation, under the Reform Bill, and previously as a matter of law. And in cases of undue hardship, the tribunal can add 2 more months. And I've said undue hardship. That's not exceptional hardship. That's a different legal test, and it's lower. Okay? So if you're a tenant and you receive a Section 13, then the obvious thing to do is to whack it into the tribunal. Worst case scenario, you'll have to pay the rent on the notice, but in all possibilities, you will have deferred the evil day of your rent increase by not less than 2 to 3 months, which is where the tribunal is now. Obviously, it's not going to be 2 to 3 months. It's going to be much more. I was actually speaking to a lot of FTT valuers recently, and I'm given to understand that currently there is no funding agreement in place for the FTT to cope with the additional workload. Okay? And I suspect, knowing the government, they will try for there not to be until they show that there is an increased workload. But there are no circumstances in which, as a tenant, you would not turn around and do this, which is why, from an agent or landlord's perspective, you're far better off to go for a very keen Section 13 and then say, but we'll take 80% of that in order to try and get them to agree what will fix at a lower rent rather than trying to take it to tribunal and push it down the road. Obviously, also, from an agent's perspective, if you're talking about your commission fees and fee structures, this is the agent's fee structure in total. Some clever version of this. Because obviously, the FTT runs on comparables. Yeah? You, hopefully, control most of the comparables. Where this gets really complicated and really problematic is in rural areas, because there ain't no comparables. And the FTT is using its own valuers, but they're the only valuers in the area. So they also work privately. Now, they won't be judging their own stuff, but there aren't many of them. And of course, the FTT will then create the market, because the FTT will say what the rent is, and then they will go out privately and value properties at that rent level, and then it will come back into the FTT, and the FTT will say what the rent is, and it's a complete circuit. So in some rural areas, the FTT will tell you and will be the source of information on what rents are, because there aren't sufficient comparables and there's not sufficient alternative market. Obviously, blocks of flats in London, comparables are not difficult. You've got like 50 other properties that look exactly the same, which you could rely on. But if you're in like some random part of rural Norfolk, then that's not so easy. Yeah? So all of this slows down rent increases. So it's not rent control, which the government was very quick to say they would not do, but it's what I am coining, this is my phrase, just remember this, trademark, rent suppression. Okay? This is a very clear effort. And I would imagine if you got Matthew Pennycook in the room and accused him of this, he would probably smile and say, yes, absolutely. This is absolutely what the government is trying to do. This is why it is the most important part of the bill. What are they doing? They are slowing down and taking masses of heat out of the market. And of course, the other point to bear in mind about all of this, as I said last time, is if the tribunal determines the rent, you can't have another rent increase for 12 months from the date of that determination. So they don't just push off this rent increase, they push off the next one and all the others. And so in fact, you never get a 12-monthly rent increase, you get a bit more. Now, of course, one of the obvious side effects of this is that all agents are going to be pressing landlords to increase rent every 12 months. And lots of landlords tend to let it lie. But if you say to a landlord you can only increase rent every 12 months, then to the market level, what are they in fact going to do? It'll be like rent act tenancies. They will increase the rent every time they can to the level that they're allowed to do so. So there's a sort of side effect here, but it will, it's undoubtedly intended to take some of the heat out of the market. Right, rent bidding. I think this is really interesting, but that's because I'm a bit odd, and I accept this. So originally, this was an amendment to the Renters Reform Bill, and the government, it wasn't the government at the time, the opposition, as they then were, had copied, word for word, some New Zealand legislation on rent bidding. Now, the problem with that, as I said at the time, is it's very hard to enforce because the New Zealand system works on the basis that you have to advertise a price, but people can bid above that price, but you just can't encourage them to do so. But the problem with that is it's a he said, she said. Oh, I didn't encourage anything. Yes, you did. You told me to. No, I said nothing. So it's impossible to enforce it. But what they've done now is they've changed it to version 2 of what happened in the state of Victoria in Australia, because they also had a New Zealand bidding model, discovered that it didn't work because they couldn't enforce it, and so they brought in a different model, which is the one we've now got here, or will have here. You must advertise properties with an actual specified price, not a thereabouts price, an actual price. Or if you're not marketing it, offers must have an actual price. You are not allowed to encourage bids, and you are not permitted to accept any offer over the price. Okay? You can accept offers up to the price, but you cannot go over the price under any circumstances. The local authority thinks you've breached this on the balance of probabilities, not the criminal standard of proof, the civil standard of proof, i.e. 50-50. It's a civil penalty of up to £7,000, or 40,000 if you keep doing it, and that means twice in 5 years. So don't get done twice. It's going to start hurting. Obviously, this is only applicable to assured tenancies. However, I had to promise faithfully that I wouldn't talk about evading this legislation as part of this discussion. Okay? So it applies to certain tenancy types, but again, one of the obvious things here, in my opinion, is it will push rents up in the short term, because what are you actually going to do? You will all advertise properties at the highest possible price you can reasonably think of, and then people will bid up to it, as long as it's not completely insane. But the market will alter to a position where it's all nearest offer, as opposed to here's a number, but whatever you give me is the number I'm going to take. So again, I think it will probably start to suppress rents over the long term, but in the short term, I suspect there'll be a bit of a spike in some markets. Written terms. All tenants must have written terms for their tenancy. I presume for most of you this is not a big problem, because you probably use tenancy agreements and like stuff in writing anyway. But you know, if you were planning to do like oral tenancies, the back of a fag packet, then stop. But, and this is the real problem from an agency perspective, the regulations are going to come along. There'll be regulations that are going to specify specific terms, other information about that tenancy, and specific wording about rights. And I don't know what they're going to say. And the problem we've all going to have is that if this is all brought into force in one go next summer, or earlier in my opinion, all of you need to have a new tenancy agreement ready to go. Either on the spot for new tenancies and renewals, or pretty soon afterwards, because there'll be a long stop. It's not the case that you'll just get to leave existing people out there. And the reality is there are only a certain number of people in the country who actually write these documents, and more than half of them are in this room right now, and I'm going on holiday at Christmas. I don't know about you lot. But the real problem is that there's a very limited number, and it was bad enough in Wales, but in Wales it didn't matter so much because the Welsh government had done 99% of the work, and it's really quite small. Whereas in England, you're talking about a hell of a lot of tenancies that are all going to need changing. Redress scheme, completely unchanged. You have to join it. And it will allow for prospective, current, or former tenant complaints. I suspect there'll be more former than all the other ones, but never mind. Must join before marketing. Schemes will charge a fee. I don't know how many schemes there are going to be. There are probably people in this room who are much better equipped to answer that question than I am. Obviously, expulsion, enforcement. But what is additional here is £7,000 rising to 40 for repeat or ongoing offences, and also rent repayment orders, which is new. And you can't get possession if you're not a member of a redress scheme. Okay. But only for assured or rent act tenancy. So if you're outside the regime, then you're fine. PRS database, again, largely the same as before, but £7,000 initially, civil penalty, rising to 40 for ongoing or repeated offences, and you can't have possession, and a rent repayment order can be taken against you. And I haven't mentioned it, but also you can't get possession if your deposit's not protected. Now, there are 2 points to note about this whole no possession thing, which I'll cover really quickly. One, you can still get possession for ASB. It doesn't apply to ASB grounds. And two, this is resetting the clock to the early days of deposit protection. So you have to be a bit grey to remember this. But when tenancy deposit protection legislation first came out, there was a really cool case called Universal Estates versus Tiensi. It was one of the first Court of Appeal cases. And what the court held is that provided you protected the deposit before the hearing, even if it was on the courthouse steps, the court still had to give you possession. And the wording used here is the same as that wording in the deposit legislation at the time. So in principle, obviously there are lots of other penalties that will still apply, but if you've issued a Section 8 notice and you're not on the database, there's no reason why you couldn't sign up for the database, provided it's processed quickly enough, the day before the hearing and turn up to court and say, ah ha ha, I signed up yesterday, you've got to give me possession. Although, again, obviously, that's got Court of Appeal all over it as a potential case. Right, last couple of things. Investigations. The investigatory powers in this are vast. Local authorities are empowered to enter the premises of any rental business without a warrant and ask questions and take away or seize any documents they find on that premises. This is more than the police can do. They don't even have to have a reasonable belief in an offence being committed. So a local authority is empowered to walk into your premises and ask you any questions they like and walk off with all of the contents of your computers. And there's a process to apply to get them back. But of course, by the time you've done that, your office will have collapsed effectively. Okay? So enormously broad powers to enter. I don't know how much they're going to be used, but I suspect some local authorities will jump on this hard. Right, agent fees. Obviously, you'll need to rethink your fee models. I just really want to warn you about this. If you go and start talking to each other about what fee models you're proposing to use, that is illegal in the United Kingdom. It is a cartel. Yes? Some of you have been fined for this stuff before. Yeah? Don't do it. It's perfectly acceptable for you to have to sit in a room while someone else talks to you about potential fee models, and I'm talking to someone about facilitating such a webinar. But if you discuss with one another what fee model you're proposing to use, that is a major problem. Okay, so don't. Okay, or at least don't get caught doing it. Make sure you do it down the pub somewhere else with no one listening. Okay. Obviously, the fact there is a problem with 12 months upfront commission, but the reality is most landlords can't easily get possession inside the first 12 months because there's a 12-month block on repo for sale or moving back in. And so in practice, I think current fee models can probably run for just now. And I would encourage you to probably let your current fee models roll for the moment while you see how the market shakes out. Obviously, I don't doubt that one or two people might go for some wild new fee model really quickly to try to corner the market. I get that. But I suspect for most people, you're probably better to let things run for a little bit. What I think is incredibly interesting is lots of unfair terms law just doesn't apply because there ain't no such thing as a renewal tenancy. So all the OFTV Fox and stuff about renewal tenancies and fees on renewal tenancies just isn't applicable anymore. Obviously, it does apply where you try and charge for sale to tenant, but unfair term stuff on renewal tenancies doesn't really apply. Finally, commencement, very hard to follow. I don't think I fully understand it. It's can be altered by regulations, but as Therese has already said, the plan is that everything ends instantaneously for all existing and new tenancies, all fixed terms end, everything becomes periodic, no Section 21, bang, on a date. To be decided. I think summer is actually more of a long stop. I don't think that Matthew Pennycook will manage to do everything in one hit. I think he'll do it in bits from late spring right through, but we'll see. Second reading, 9th of October, and then push through Christmas, through committee stages. I might hit the House of Lords before Christmas, I think. Possibility. And then obviously in force early in 25, probably early spring. I mean, do I need to point out the fact that the government already cut recess to 1 month, which is normally a 2.5 month recess? So they're not exactly hanging about here. Okay. But there's a huge amount of pressure on you, in my view, to get all your documents revised, update all your IT systems and internal processes, don't know how you're going to manage this, and train all your staff at least twice because they'll be asleep the first time. So you'll have to do it again. And even then, you're still likely to find yourself at risk. So just the most epic amount of work has to be achieved prior to next summer from the perspective of agent businesses. And I would strongly advise you to start now. I appreciate that this is first reading, and I've said, well, things can change, but the reality is not many things are going to change. So you need to start thinking about staff training and processes now. And I think those of you who've got, obviously want to get onto IT suppliers, because IT suppliers always take longer than they say they're going to. Sorry to IT suppliers in this room. But they do always take longer than they say they're going to. And it will take time. Plus, you're going to have to train your staff in your new IT systems as well. So there's a block in there as well. Contact details, I've overrun. I'm sorry. Hopefully it was more interesting than I'll get away with it.
David, thank you very much.